All right. Good afternoon. It's been a little bit. It's been a busy week. I've been trying to get a live stream in the last couple days, but it's been busy. Today's also busy. I'm on a bit of a time crunch, so I've got a hard deadline to stop. So I'm gonna jump in pretty quickly. I've been trying to do a sort of omnibus update on all the dumb stuff that delete laws has done this week. I don't have time today. No guarantees. I'm going to try to do it tomorrow. Um, Today, though, this is a sovereign citizen in federal court. His ridiculous filing and the court's response to it. It's wonderful. I had intended to do this as a cold read, but I was talking about sovereign citizens with my friend, and he said at some point judges just have to get sick of them and start ruling against them right off the bat. I said, it's funny you say that. And then I read this to him, and it was even better than I thought it would be. Hey, Empty Woods. So it's glorious. And so what I've got today is a motion to dismiss, handwritten and filed by the defendant, the sovereign citizen. The judge's order on the motion to dismiss, and then I have a contempt order. All from the same case. He's got a couple cases. At some point, I'm probably going to dig into Pacer and look for more of it, just because it's absolute gold. And while I'm thinking of it, so I am live on Facebook and on YouTube. So if you're watching on Facebook, please head over to YouTube and subscribe. That would really help me out. Go ahead and watch on Facebook all you want, but if you could subscribe on YouTube, that would be wonderful. And those of you on YouTube, like, share, subscribe, do all that stuff. With that, I'm going to just jump right in. So on the motion to dismiss, it's captioned Henry Underwood versus United States of America, which it's really the other way around. This is a criminal prosecution, so it's United States of America versus Henry Underwood. This is in the Northern District of Indiana Federal Court, and it's a motion to dismiss. Handwritten. I'm going to do my best to convey the grammar and nonsense in the writing. I try not to be too harsh on people's grammar and writing, but when it's a sovereign citizen, it's part of the fun. So, motion to dismiss comes now. I, Henry Underwood, the accused, sui juris by special appearance by standby counsel Stanley Campbell, in what looks like all lowercase Stanley Campbell, praise this honorable court, move this motion thereof. 1. Every judge in every state took a oath to follow, period. The law of the land, which consists of 1. The Constitution, written by we the people under the authority of God. 2. Empower, control, and restrict government servant. But only one government servant, apparently. 2. Common law, which is written by God. No. common law, as we know, is judicially created. It's the written opinions, the cumulative written opinions over time. So common law, which is written by God in the heart of men. And 3, constitutional statutes, which are written by legislat. I'm not quite sure what legislat is, but that's okay. Any statute or code of the aforesaid, and there are many, period, is null and void. And that is why we need a constitutional law protector who knows the difference. The real law, the common law, is the real law, the supreme law of the land. The codes, rules, regulations, policy, and statutes are not the law. Self versus Ray. Which isn't well cited. Legislated statutes enforced upon the people in the name of the law. That's kind of an orphan sentence. I don't know how that ties in. 2, neither the U.S. Congress nor any state Congress has the authority to write statutes that control peoples, and that's the possessive, people, apostrophe S. No idea, Alpha Fox Adam. I mean, this is such utter and complete nonsense that it's hard to figure out. So, it up to the people to control their own behavior. Congress absolutely has no authority to legislate outside of Article 1, Section D. 8, Article 1, Section 8. In order for statutes to become law, the legislated must be given authority by we the people, which is found under Article 1 and 8, I assume again, which is restrained by Article 1, Section 9 and the Bill of Rights. This is where the people attention should be. This is kind of hard to read, handwritten and all. So, if Congress writes statutes outside of Article 1, Section 8, or statutes that violated Article 1, Section 9, or the Great Bill of Rights, the following general rule, in quotation marks, of the United States Supreme Court is to be applied. I don't know what the general rule of the United States Supreme Court is. And herein is the power of the county sheriff. Because as we all know, in the sovereign citizen lore, the elected county sheriff is the only legitimate government for some reason. I don't understand it, but the general rule is that an unconstitutional statutes, though having the form and name of law, is reality no laws, but is wholly void and ineffective for any purpose. He has so many random capitalizations, it's insane. Since its unconstitutionality dates back from the time of its enactment in in legal contemplation. It is as inoperative as if it had never been passed. Since an unconstitutional law is void, the general principles follow that it imposes no duties, confer no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no act performed under it. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operated to supersede any existing law. Indeed, insofar as statutes run counter to the fundamental law of the land, the Constitution, is superseded thereby. No one is bound to obey an unconstitutional law, and no court are bound to enforce it. Bonnet v. something or other, and Norton versus Shelby County. Number 3, is any of these false allegations in the Constitution for the United States of America? Question mark. This is painful grammar. Is any of these false allegations an Article 1, Section 8, racketeering, murder, witness tampering by attempt of murder, witness tampering by physical force, felon in possession of a firearm, and use of a firearm in furtherance of a serious violent felon? Is any of these charges in the Constitution, which you guys took an oath to obey by? Did the legislated Congress pass these laws? They did. Even if so, Article 1, Section 10 states, no states shall pass no bill attainder. Yeah, this isn't a bill of attainder. Or expo facto laws, not ex post facto, meaning a law with retroactive effect, but expo facto law. Expo facto law mean pass no law that wasn't law before. That would mean you couldn't pass any new laws. Ex post facto means you can't make murder illegal and then charge someone for a murder that happened before the law. That's what ex post facto is, not you can't make a new law that wasn't a law before. That would be ridiculous. So United States codes suspend the Constitution, suspend and violate Article 1, Section 10. Article 1, Section 10 also states can't pass no law impairing the obligation of contracts. Yeah, that's the contract clause. But the funny thing about the contract clause is states can't interfere with contracts. Like if I have a contract with Alpha Fox Adam, the state of Utah can't come in and say, yeah, we're altering the terms of that contract. But the federal government can. It's states can't alter contracts. That's why, like, bankruptcy is entirely altering contracts. That's why it's all federal, not state. But yeah. So Article 1, Section 10 also states can't pass no law impairing the obligation of contracts. The government are companies / corporations. No. which suspend and violated Article 1, Section 10. The government can only deal with Article 1 person, the imaginary, having no reality or substance, cannot create or attain parity with the real. See Penhallow versus Domes. None of my statues in the United States Constitution for the United States of America. That's a whole sentence, apparently. Thereof, I praise this honorable court dismiss racketeering murder, witness tampering by attempt murder, witness tampering by physical force, felon in possession of a firearm, and use of a firearm in furtherance of a serious violent felony. I got no violent on my record. By the way, I also will like to object to USC, United States Codes. They suspend the Constitution. Signed, Henry Underwood, without prejudice. So that was a thing. Yeah. So, and this is kind of embarrassing for me, because for those of you who were here for my last live stream discussing the Delete Laws lawsuit, I said over and over, it's never RICO. We even said RICO is the lupus of the legal world. But just like lupus, it's never RICO unless it is. And this is. So that was Mr. Underwood's motion to dismiss. The judge wasn't a big fan of that filing. So this is her opinion and order denying motion to dismiss. And it's glorious. Defendant, proceeding pro se, has filed another motion to dismiss, ECF number 131, along with a document titled Judicial Notice and a Writ of Habeas Corpus. By now, these are familiar filings by the defendant, as he continues to assert that the indictment charging him with violation of various statutes is unlawful because neither the U.S. Congress nor any state Congress has the authority to write statutes that control peoples. She writes it in the possessive as well, as since it's a direct quote, but sick. He further asserts that Congress has no authority to legislate outside of Article 1, Section 8, with footnote number 1. That provision enumerates the scope of legislative branch's powers of the Constitution, that Congress exceeded its authority when it enacted the laws under which he is charged in this case. Additionally, he asserts that the statutes charged are unconstitutional under Article 1, Sections 9, the powers which sets forth the powers denied to Congress, and Section 10, which sets forth the powers denied to the states, such as the Contracts Clause. Defendant is wrong, and this court has explained to him in previous orders. See ECF numbers 123 and 128. Nevertheless, he continues to make frivolous sovereign citizen type filings and take up this court's time with repetitive motions challenging the charges against him, let the court make this absolutely clear to the defendant. A generalized assertion that all laws passed by Congress are null and void under the Constitution is not a get out of jail free card in a Monopoly game. There is no genie in a bottle that, once a motion is filed 3 times, will release the defendant from the custody of the United States Marshals Service. Isn't that a glorious paragraph? There is no get out of jail free card. This isn't Monopoly. There is no genie to get you out of the custody of the United States Marshal Service. I love that. To reiterate what this court has previously told the defendant. 1. Defendant has been charged in 5 counts of a 6-count superseding indictment with violations of 18 U.S.C. 1958A, racketeering murder. Like I said, it's never RICO, except when it is RICO. 18 U.S.C. 1512A, 1A, and C, witness tampering by attempted murder. 18 U.S.C. 1512A, 2A, witness tampering by physical force. 18 U.S.C. 922 G1, felon in possession of a firearm. And 18 U.S.C. 924 C, use of a firearm in furtherance of a serious violent felony. These are very serious charges against him, and his time would be better spent preparing a defense to them than relitigating previously denied motions. Maybe Delete Laws needs to read that sentence right there. His time would be better spent not relitigating previously denied motions. Number 2, defendant's filings titled Judicial Notice, which continue to espouse sovereign citizen theories, will continue to be stricken by this court, as the Seventh Circuit advises they should be rejected summarily, however they are presented. That's United States versus Benaby, 7th Circuit, 2011, citing cases Bay versus State of Indiana. Very much so, Empty Woods. I believe this is a case where he shot and killed a high school sports coach and had been acquitted in state court, I think. And the feds took it up. 3, a district court maintains subject matter jurisdiction so long as the indictment charges the defendant with violating a valid federal statute in the United States Code and alleges an offense against the laws of the United States, citing United States versus Thomas. The indictment in this case tracks the statutory language for the various crimes the defendant is charged with committing, all of which on their face charge the defendant with offenses legislated by Congress as crimes against the United States. This is sufficient to give this court jurisdiction. United States versus Houseman, 7th Circuit, 2003. An indictment that tracks the words of a statute to state the elements of the crime is generally acceptable. And while there must be enough factual particulars so the defendant is aware of the specific conduct at issue, The presence or absence of any particular fact is not dispositive. So that is in effect the federal criminal equivalent of the Civil Procedure Rule 8A, which we've discussed in the last couple Delete Laws live streams about the pleading standards. You don't have to plead everything, you just have to plead enough that a crime could be there. 4. Despite the defendant's assertion to the contrary, the Supreme Court has long recognized that the Constitution authorizes Congress to enact criminal laws. See, e.g., United States versus Comstock. Thus, the Constitution, which nowhere speaks explicitly about the creation of federal crimes beyond those related to counterfeiting, treason, or piracies and felonies committed on the high seas, or against the law of nations, nonetheless grants Congress broad authority to create such crimes. Indeed, Congress can pass criminal laws under one of the specifically enumerated powers in Article 1, Section 8 of the Constitution, such as the Necessary and Proper Clause, U.S. Constitution, Article 1, Section 8, Clause 18. The War Powers Clause, Constitution, Article 1, Section 8, Clause 11, and the Commerce Clause, U.S. Constitution, Article 1, Section 8, Clause 3. I would venture a guess that the vast majority of federal laws, and this isn't just criminal laws, but all laws, are passed under the Commerce Clause. Or at least there are more laws passed under the Commerce Clause, I would guess, than any other. Because it's very broad. That's why, like for wire fraud or mail fraud or so many crimes, it's you hear about the jurisdictional hook being interstate commerce. They use the internet, which is interstate commerce. They use the mail, which is interstate commerce. And that's what gives the feds jurisdiction in most cases. So, number 5, absent a challenge to the constitutionality of a particular statute, because he's challenging the constitutionality of all statutes, but absent a challenge to the constitutionality of a particular statute under which he is charged, and a supporting legal basis for that motion, not an assertion that all federal criminal statutes are unconstitutional, the arguments in defendant's motion to dismiss go nowhere. It is time for the defendant to move on from these arguments. His trial is scheduled to begin in a little over 2 months. The motion to dismiss and the writ of habeas corpus are denied. The document captioned judicial notice is stricken, but shall remain in the record for completeness. So ordered on November 18th, 2022. Judge Holly A. Brady, United States District Court. Isn't that a glorious smackdown of sovereign citizen nonsense? It's so good. And I think we're going to see more of it as time goes on. Judges are sick of it. it wastes time, it wastes resources, and it's frivolous. It's nonsense. So, but no, like I said, I'm on a time crunch, so I'm going to move on to the last document, which was filed the day before. But I believe this was in a different case. It most certainly was a bench slap. So I think this was a different case because, you know, criminals tend to have multiple things going on. And this is discussing a trial that happened in September when the previous documents we read that were done a day later contemplate trial in 2 months. So hang on just a second. All right, sorry. But this is a contempt order in what I think is a separate case, but it's the same judge, same defendant, United States of America versus Henry Underwood, Northern District of Indiana. So, opinion and order. Defendant, who chose to take stand on his own behalf during his September 2022 trial, repeatedly refused to answer a question posed by the government during cross-examination. The court advised defendant that he could be held in contempt of court if he refused to answer. Still, defendant refused. The court, on its own motion, now finds defendant in criminal contempt of court. So, you have a Fifth Amendment right to not testify. You can't be compelled to testify against yourself. But if you take the stand to testify, you have to answer the cross-examination with very limited other circumstances, which will generally be hashed out in motions beforehand. Like if you have, say in Mr. Underwood's case, if you have another trial forthcoming, you can probably plead the Fifth to questions that'll get you hemmed up in that other trial. Of course, you probably shouldn't open the door to those on your direct testimony, so you've got to be careful. But he wanted to have his cake and eat it too, and the judge wasn't having it. So the background facts. Defendant was charged with a single count of being a prohibited person in possession of a firearm in violation of 18 USC 922 G1. The charges stemmed in part from a December 2019 shooting in Fort Wayne, Indiana. Defendant, accompanied by 2 other individuals, went to a home to confront an individual inside. After a short verbal altercation, one of the 3 individuals fired several shots into the home. Exactly. So I'm thinking this is actually a separate trial, but it's based on the same events. I don't know the exact procedural posture that led to it, but if you remember in the previous order denying the motion to dismiss, the judge mentioned that he was facing 5 counts out of a 6-count superseding indictment. I have a feeling this is that 6th count from the superseding indictment. I don't know why it was tried separately, but apparently it was. And if you notice, the charges stemmed from a shooting where the defendant was accompanied by 2 other individuals. RICO is a criminal organization. Conspiracy. Defendant proceeded to trial where he represented himself. On the 2nd day, defendant took the stand and denied ever being in possession of a firearm, although he admitted handling a magazine containing ammunition. On cross-examination, defendant was asked if there was an individual standing by the car that transported defendant to the home. Defendant confirmed that there was. Defendant was then asked if he knew the identity of the individual. Defendant confirmed that he did. Defendant was then asked to identify the individual. He responded, "I'm not. I'd rather not. I'm not. I'm not about to say no names because I'm not going to be no witness in no cases. I'm not about to make it seem like I'm snitching on nobody. I don't want nobody calling me, asking me to get on the stand, try to get somebody sent to prison. I disagree with that." Apparently, Mr. Underwood believes in the old adage, snitches get stitches. The court directed defendant to answer, at which time he asserted his Fifth Amendment rights. But the identity of a different person isn't incriminating against yourself, is it? Besides which, you waived your Fifth Amendment rights by choosing to testify. During a short sidebar, defendant admitted that his answer would not incriminate himself, but someone else. The court then advised him that the Fifth Amendment did not apply, and again directed him to answer the question. When defendant continued to refuse, the court decided to go back on the record and advised defendant, "If you choose not to answer the question, then you'll be held in contempt of court. I'm instructing you to answer. You elected to take the stand. You elected to testify in this case, and therefore, the prosecution, the government, is permitted to ask you relevant questions. This is a relevant question, so I'm going to direct you to answer the question." Back on the record, the government again asked defendant to identify the individual near the vehicle. Defendant continued to refuse to answer. At this point, the jury was excused from the courtroom. Juries love being excused from the courtroom, having their time wasted due to defendants being jackasses. The court and defendant then discussed defendant's reasons for refusing to answer the question. In essence, defendant did not want to be viewed as a snitch. When asked for his thoughts on the matter, the government asked that, if he refused to answer the question, defendant be forbidden from offering testimony on redirect. Sanctions, immediate sanctions. The court then took a recess. At the end of the recess, the court again asked defendant if he would answer the question. Defendant, again asserting that he was not a snitch, confirmed that he would not. The court then told defendant, Mr. Underwood, let me explain something to you, okay? If you choose not to answer that question, and you have not articulated any basis which might indicate that you are refusing to answer that question based upon any Fifth Amendment rights against self-incrimination, because she is not asking you to incriminate yourself. So if you refuse to answer that statement, I am advising you that you may be found in criminal contempt. And if I find that you are in criminal contempt of court, then you could face a fine or an additional term of imprisonment of up to 6 months, which may be served consecutive. That is, in addition to any term of imprisonment which might be imposed as a result of this case or any other criminal charges which you may face. Do you understand that, sir? I mean, for all the time he's facing for RICO and all the other counts, 6 months is chump change, but it's still 6 months. While defendant made clear he did not agree with the requirement that he answer the question, he confirmed that he understood the court's warning. When asked whether, knowing the penalty, he still refused to answer the question, defendant responded, "Yes, ma'am. I object to becoming a police officer." Okay, I wasn't expecting that response. I object to becoming a police officer. Defendant was informed that the issue of his contempt would be taken up later. Turning to the government, the court denied its request to limit defendant's redirect testimony. After a discussion of other trial-related matters, the jury was brought back into the courtroom. The following exchange occurred. Question: Mr. Underwood, you've indicated that you know the individual of the other male at the Monroe Street address. Who is that other individual? I wish not to answer that question. Who is the individual who shot into the house on Monroe Street? I'd rather not answer that question. With that, the government ended its cross-examination. Legal discussion. A court may find a person in contempt under 18 U.S.C. 401 sub 1 for misbehavior in its presence or so near thereto as to obstruct the administration of justice. A conviction under this section requires proof of an intentional and objective obstruction to the administration of justice. United States versus Griffin. Citing United States versus Seal. Section 401 sub 3 allows for a finding of contempt for disobedience or resistance to a court's lawful writ, process, order, rule, decree, or command. 18 U.S.C. 401 sub 3. A contempt conviction under this subsection requires proof that the violation of the court's order was willful. Doe versus Maywood Housing Authority, 7th Circuit, 1995. As is true for other substantive criminal offenses, criminal contempt must be proved beyond a reasonable doubt. Griffin. The federal rules of criminal procedure give the court 2 options for pursuing a charge of contempt. Rule 42 sub A provides that any person who commits criminal contempt may be punished for that contempt after prosecution on notice. Meaning the judge says, I think you're in contempt. We're going to look at that later, which is what she did. The notice must state the time and place of the trial, allow a reasonable time to prepare a defense, and state the essential facts constituting the charged criminal contempt and describe it as such. Federal Rule of Criminal Procedure 42 sub A sub 1. Subsection A also requires the court to request that the government prosecute the contempt. And if the government declines, the court must appoint another attorney to do so. Federal Rule of Criminal Procedure 42 sub A sub 2. Rule 42 sub B, however, states that notwithstanding any other provision of these rules, the court may summarily punish a person who commits criminal contempt in its presence if the judge saw or heard the contemptuous conduct and so certifies. So here the court saw the contempt. So that means she can summarily punish. She can say, you're in contempt right here, right now. No trial, no prosecution. Because defendant's conduct took place in the presence of the court, the summary procedures of Federal Rule of Criminal Procedure 42 sub B are available and appropriate. Defendant repeatedly refused to answer the government's questions after repeated commands from the court that he do so. This brings his conduct within the scope of 18 U.S.C. 401 sub 3. And because the court repeatedly advised defendant of its intent to hold him in contempt and further advised him of the potential penalties, the court finds that the defendant's contemptuous conduct was willful. The court finds all the above beyond a reasonable doubt and finds defendant guilty of criminal contempt of court. Conclusion. For these reasons, the court finds defendant guilty of criminal contempt. The sentence for the criminal contempt will be addressed at sentencing for the underlying conviction. So that gives us a spoiler that he was found guilty of one of the counts in the September trial. So at the very least, he's going to be spending time in jail. Well, in prison, federal prison, big boy prison. So I had meant to do a cold read for the sovereign citizen motion to dismiss and order denying it. This one was a cold read. So it actually, surprisingly, wasn't addressing any sovereign citizen beliefs directly. He's still flouting the authority of the court, but not for sovereign citizen reasons, but for prison rules reasons. Snitches get stitches. But he's still flouting the authority of the court. He still thinks the rules don't apply to him. So it wasn't quite what I expected. I think it was still worth looking through. I hope you guys did too. Like I said, I'm going to dig through Pacer and see if there are more interesting filings by this guy, because I have a feeling there might be a dozen or so that are worth reading for a chuckle. But I could be wrong, so we'll see. But I also, like I said, I haven't had time in the last week to do any streams, but there are things I want to do. So going forward, I still need to to get started on the Alex Jones bankruptcy. As I mentioned in my community post, bankruptcy was my favorite subject in law school. I've done a little bankruptcy work outside of law school. It's interesting stuff. I glanced at the bankruptcy filing, but that's a form. That's not the super interesting part. I understand there have now been motions filed, so I'll take a look at those and hopefully do a stream on those. One of the Oath Keeper January 6th defendants has gone full sovereign citizen. I need to do a separate live stream on that. It's gold. It's, in the words of Law Talk with Mike, it's deliciously awful. And I still need to do my weekly recap of delete laws. He has several filings in the last couple weeks, which are all nonsense. But he also, I'm not going to play any of his live streams. And it's not because I'm scared of a copyright strike. I don't think he has the balls to sue an attorney. You know, he's not going to run up legal fees against me. But the reason I'm not going to play the videos is because I don't want to listen to his stupid voice and his little chipmunk laugh. But there are a few live streams that need to be addressed. So, unfortunately, I didn't have time to do that one today because that's going to be a multiple hour live stream, I have a feeling. So I'm going to try to do it tomorrow, but there's no guarantees. If you see that Alpha Fox Adam, send it my way. My email is on my YouTube About page, and I have a Discord in there too, assuming the link works. I don't really use Discord other than dragging documents out of Merb's Discord, because why pay the Pacer fees when I can pull them up when someone else has downloaded them? But with that, like I said, I've got my brother-in-law's birthday dinner tonight. I've got to go get ready for that. So thank you all for watching. Remember, like, share, subscribe. If you're watching on Facebook, go to my YouTube page. There's a link on the Facebook page somewhere. Go to the YouTube page and subscribe. I could really use your subscription over there, even if you watch on Facebook. And with that, I will see you guys soon. Have a great rest of your Sunday. Thanks for hanging out.